Good morning. Are you Willie Edward Pew Jr? Give me just a second, Mr. Pew, to get this pulled out. Mr. Pew, in cause number 25, DCCR 1835, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon from October 23rd of 2025. The indictment alleges that you were previously convicted of the third-degree felony offense of unauthorized use of a motor vehicle, May 13th of 1996. Two cases of that same offense on that same date. After those were final, you were convicted of the felony of unlawful possession of a firearm by a felon, February 20th of 2007. You were also convicted on that same date of possession of a controlled substance, a third-degree felony. After those were final, the indictment shows that you were convicted of evading arrest or detention with the use of a vehicle, April 15th of 2019. And on that same date, also possession of a controlled substance, a second-degree felony, and unlawful possession of a firearm by a felon, also on that same date. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to go forward probably on, it looks like, counts 1 and 2. That would make this a second-degree felony for a 14-year term in prison. You have every right to reject that. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
Okay, I'll get that done. Ms. Malfino, is there any reason to believe that that offer would change? Any information you think you don't have at this point?
Judge, just to be candid with the court and not to give the defendant any false hope, I'd like to speak with the officer actually in person rather than the review of his report. There might be some question as to the validity of that search. I'll certainly bring that to the court's attention well prior to the trial docket. That would be the only reason after speaking with him that I would consider altering the offer with the court's permission. He's been before you, Judge, multiple times with 10 and 12-year sentences reason for the
And Judge,
I could do that very quickly.
if you'd rather just reset a week or two.
I would I would rather if you can get that done in 2 or 3 weeks, just to do a regular reset. That way we can all say with at least some certainty that the offer is what it is based on the evidence and based on your discussions, or if something changes, then we'll take care of it one way or the other. So let's do this. I'm going to delete that plea bargain rejection for now. I'll reset it for about 3 weeks. That'll give Ms. Malfino time to speak in person with that officer, get with Mr. Rojas. He'll get with you, let you know what the final discussions come out to, and then we will see where we get at that next court date. Okay, you can go back with the bailiff.
This might read different on the front because the conversation.
Sure, yeah. That's good. Brian Trejo.
I'm going to ask for a reset on that, Judge. I'm still trying to run down witnesses that were.
Okay, it's pretty new. Mr. Nichols, and we'll set Brian Trejo. I think that's all you have.
Sarah Jordan's going to be reset along with the co-defendant.
I think I already got that one. Yeah.
That's it. Thank you.
Thank you.
Good job. Good job.
Mr. Parker,
Yes, ma'am.
you've got Christopher Holman.
Yes,
Okay.
Yeah, but in fact, with the guys, if we go out on Wednesday,
Mr. Holman?
Fine, Judge.
We need him to get a fingerprint real quick first, please.
I got everything resolved with you. It's only Ashley that I can't do it.
I wouldn't try to call on anybody.
pretty bad. Just, I mean, I'll, maybe this week.
Good morning, sir. Are you Christopher Holman? Speak up, please.
This month.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Holman, in clause number 24, DCCR 0814, you're charged with the state jail felony offense of theft of property with previous convictions from February 7th of 2024. The indictment alleges you were previously convicted of theft August 4th of 2020, and then after that was final August 10th of 2021. And how do you plead to that charge?
Guilty.
And are those prior convictions of theft true? Speak up, please.
Yes, ma'am.
And did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1 with Mr. Parker.
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Holman is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. And at this time, in accordance with your agreement, find you guilty of theft of property, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff.
If you found this video informative, please like, subscribe, and turn on the bell icon so you never miss the latest courtroom hearings, legal updates, and case analysis.